The showdown over CAA reached the top court's doors once again. The Supreme Court has now issued a notice to the centre on over 200 pleas challenging the Citizenship Amendment Act, but it has refused to put the law on hold. The centre has been ordered to respond before the 2nd of April, and the matter will be heard next on the 9th of April. The petitioners, remember, sought a stay on the CAA and urged the court to direct the centre to not grant citizenship to any refugee till the matter is sub judice. But the Supreme Court has refused to issue any stay on the grant of citizenship and instead directed the petitioners to furnish further documents by the 2nd of April. BRS leader Kavitha, who has been in ED custody since the 15th of March in connection with the Delhi Excise Policy scam, has now filed a writ petition in the Supreme Court. Kavitha's fresh petition challenges her arrest and remand by the probe agency, calling them illegal. Now, her petition has challenged Section 19, one of the PMLA Act. This comes hours after Kavitha withdrew her pending petition in the top court. Her lawyer has said that her plea has been rendered pointless as it sought her protection from arrest. Her lawyers have reached out to the CJI meanwhile, seeking an urgent hearing in this case. The fresh plea also says that the remand order does not adhere with Article 141, which states that the law declared by the Supreme Court shall be binding on all courts within India. Kavitha, who will be in ED's custody till the 23rd of March for interrogation, was, remember, arrested after a search operation was conducted at her Hyderabad residence on the 15th of March.
In fact, rules 2024 is concerned. Today, the Supreme Court, there were around 237 petitions pending, listed before the Supreme Court, including 5 to 6 petitions which had challenged the constitutional validity of recently enacted rules 2024. In fact, remember, when all these petitions were filed in 2019, even then the petitioners had sought a stay. But then Attorney General K.K. Venugopal stood up and said that since rules have not been framed, rules have not been notified, there is nothing to be implemented anytime soon. At that moment, the Supreme Court did not stay, but now the petitioners argued that since rules are here, it has been notified, let this CAA be stayed till the Supreme Court adjudicated on the petitions which have challenged the constitutional validity of CAA, because once the centre starts giving citizenship, it cannot be revoked. Even under international conventions, once a citizenship is granted, it cannot be revoked. But the centre said there is a three-tier system in place. There is the empowered committee system, and nothing, maybe immediately nothing is going to happen. But these petitioners before the Supreme Court will not be affected in any ways. The CAA is to grant citizenship, not take away citizenship, and needlessly the fear of NRC is being raised.